Most people look at the law as something really complex to understand. That is a no-go mindset. Look at the architecture of the Portuguese insurance law. It's not just a collection of rules, it's actually a structural blueprint designed to organize an entire market under the law 72/2008. If you want to dominate, you must understand the foundation. Don't focus on the noise, focus on the blueprint. Once you see the structure, you can anticipate the move instead of reacting to it. There is always a tension between the weak and the strong, and the law makes the recognition of this. It shifts away from the last century in terms of the liberal, chaotic situations to order and to protect the policyholder in mass risk scenarios. But here is the critical part. It can refuse to crush the industry competitive understanding. And that is quite important because it's all about the balance. You protect the consumer, but you keep the business always moving. And that is really the modern paradigm. If you cannot master the tension, you are already losing the game. You have to know the structure. It's a three-way understanding of the same environment and the same market. You have first the non-life, covering all the damages, then you have the life, covering the people, and then you have the general part. And these are the common rules that make the governance of every single bond that you write. Everything else falls under these different classifications, except for very specific specialized areas like cyber risk insurance, for example, that can operate in different international policies and treaties. So stop trying to treat every policy the same. Know the classifications at the different types, or you will fail the execution. Now, it's quite important as well to understand the deep foundations of the legal system. It's not just one level. You have the surface, the legal reality, but underneath that, you have the dogmatics, the legal norms, and the deepest layer, the normative principles. And most operators, they stay on the surface. They only see the problem, but the real players, they go deep. You have to understand all the key concepts in order to extract the true normative intent. If you don't understand the depth, you will never master the surface as well. Where does the power really come from? You have those immediate sources that are, of course, the law, and then the mediate sources like custom or the doctrine. And in Portugal, the law is supreme. Do not confuse it with the Anglo-American system that judges make the law through precedent. Here, the judges, they apply the law with their conscience. The doctrine and monographs, they are just persuasive. They have no binding power. Always identify the immediate source if you want to win an argument. Every legal norm has an anatomy. It's kind of a machine. You have the hypothesis, what the lawmakers they can anticipate, and then you have the concept, the logical bridge. And then you have the status, the command, the result. Think about it. It's kind of a formula. This machine runs on four gears: imperative, the different combinations or different interpretations, the general conditions, and of course, the proper interpretation and the ethical principles guiding the decisions. It is designed to be broken and then enforced. If you cannot map a rule to this anatomy, you do not understand the rule at all. You must learn to make the different classifications of the codes. Is it public or private? Is it universal or local? You have to know if a rule is imperative or optional. If a rule is imperative, you cannot bypass it, no matter what you negotiate. And many CEOs, they lose everything because they try to negotiate a public interest clause. Don't be that guy. Know the flexibility of the rule before you put it on paper. If it is optional, use it. If it is imperative, obey it. Hierarchy can be everything. If you don't know the hierarchy, you are flying blind. At the very top, you have the Constitution, then the international conventions, then the laws, and then the decree laws. And finally, at the bottom, you have the regulatory acts. A lower act cannot contradict a higher one. It is a validity flow. When you are building your compliance, check the hierarchy first. If your strategy is based on a low-level ordinance, then violates the Constitution. Your strategy, it's already dead. So, how does a law live? There is a life cycle. It starts with elaboration, then the approval, the promulgation, then the publication, and finally the vacatio legis. If the president doesn't sign it, doesn't exist. It's that simple. And eventually, every law dies. It ends through revocation or caducity. If it's not definitive, know where your law is in this life cycle. If you are operating on a law that has already faced the expiration, you are wasting your time, definitely. And then when the things break, you have to know the escalation staircase. You start with the natural reintegration, fixing the state of affairs. Then you move to the necessary equivalence, then to the compulsive means. And if they still don't listen, criminal sanctions. You don't start with the threat of jail. This is amateur. You start by restoring the baseline, but keep the staircase in mind. If you don't have a mechanism for enforcement, you don't have a law. You have what is a recommendation or an idea of something. Now, let's talk about the structural failures. You have nullity, the annulability, and inefficacy. Nullity is the total distraction, as if the contract never happened. Annulability, it's conditional. Someone has to pull the trigger to cancel it. And inefficacy, it's even more subtle. The contract is valid, but it is invisible to third parties. Think about your rents. If you don't register, it is ineffective against creditors. Don't create legal vices in your deals. Verify everything. Who makes the interpretation of the law? Is it authentic, official, judicial, or doctrinal? And the authentic interpretation binds everyone. From a judicial interpretation, only binds the parties in the suit. If you think a court ruling sets a universal rule, you are completely wrong. And then you have the criteria, objective or subjective, historical or actualist. Are you looking for what the lawmaker meant or what the law means today? And these are the questions that win the cases. You need an interpretive toolkit. Start with the literal and grammatical, then move to the logical, historical, and the systematic. If that is not enough, you look for the conceptualization, the ratio legis, the purpose. And what is the outcome? It is declarative, it is extensive, it is restrictive. You are building a case or a defense. Every tool serves a different purpose. Don't use a hammer when you need a scalpel. Now, what happens when the law is silent? You have a gap. You look for an analogy, a similar scenario. But be careful. You cannot use analogy in exceptional laws or criminal matters. That is a trap. If analogy fails, you must create the norm ad hoc. You have to ask yourself, if I was the lawmaker, what rule would I write here? This is where the true legal minds are separated from the bureaucracy. And finally, you need to master the principal diplomas. You have the core infrastructure, like Decree Law 72/2008, but you have also consumer defense and anti-discrimination laws. This is your master plan. These are the tools of the trade. If you operate in the Portuguese market, you need to have this list in your brain. Don't look for excuses, look for the rules. Master the architecture and execute with precision. Now, let's get to work.